Hello students, greetings of the day. Today we are going to discuss a very important topic, that is personal injury to employee, doctrine of notional extension and doctrine of added peril. The scheme of discussion is as under. We will start with the introduction, the judicial overview on the issue, the expansion of an employer's premises, additional risk theory or doctrine of added peril, followed by the conclusion. To start with the introduction, the idea that an employer is responsible for compensating an employee for injuries sustained while on the job is laid forth under the doctrine of notional extension. However, this principle's foundational assumption holds that employers are liable beyond the physical boundaries of the workplace. It stipulates that even if the personal injury has happened to the employee at a place or doing work that is incidental to his work, the employer shall still be liable even if the employee is not at the leading work site. For example, a person uses the transport provided by the employer to do the marketing and sales. He takes up that transport at the end of his shift and decides to do the marketing on his way back home. During the journey, if he encounters an accident, the accident shall be presumed to be incidental to the work and the employer shall be liable to pay compensation for applying the principle of notional extension. The employer frequently invokes the doctrine of added peril as a defense. According to this doctrine, the employee's injury must have been caused by work he voluntarily performed and for which the employer has not assigned him the job. For instance, suppose X hired C to work on fencing the road. However, C involved himself in road construction instead, which resulted in a car accident. In this case, C is liable because the fencing work was assigned to him and not road construction per se. Furthermore, the work assigned by X was not incidental to the work performed by C. This concept established a novel form of legal responsibility. It imposes a liability on employers for workers who have suffered injuries on the job and should receive financial compensation. Responsibility rests more on the nature of the employment connection than on the doctrine of strict responsibility. the amount of compensation is determined by the act itself. It will be paid to any worker who becomes disabled as a result of an accident on the job. An important factor in salary is not the employee's suffering or treatment expenses, but rather the disparity between the pre-accident and post-accident wage earning capacity. The responsibility for compensating the employee does not hinge on the employer's negligence or wrongful actions. The issue of compensating an employee who contributes to negligence does not absolve the employer from their need to provide compensation. Although non-compliance with laws and safety measures can be a valid reason for the exemption in the event of an accident except death, the negligent behavior of an employee cannot be seen as a deliberate act of disobeying an expressly stated instruction. In personal injury cases, the employer is responsible when an employee sustains an injury as a direct result of an event that transpires on the job and is caused by the employee themselves. Now, let us discuss the judicial overview of the issue. The significance of distinguishing between accidents and injuries was brought to the light in 1976 case of Shrimati Sundarbai versus General Manager Ordnance Factory Khamaria, Jabalpur. An injury is defined as any kind of bodily harm that a worker experiences on the job, whereas an accident is defined as an unexpected and unplanned event that happens to a worker. When an accident occurs on the inside of a person, both the accident and the injury may occur at the same time. Even if the damage was partially caused by something outside of the worker's control, the job being done at the time can still be regarded as an injury. Imagine if the stress of one's usual work made the injury worse or worsened it. If that's the case, the usual stress of the work is the best way to prove a causal relationship between the two. Physical harm sustained in an accident is typically what the word injury refers to. On the other side, symptoms like mental collapse, emotional trauma, or psychological anguish will also be a component of this specific type of personal harm. While continually commuting between a cooling plant and a heating room, an electrician contracted pneumonia and died in the case of Indian News Chronicle versus Mrs. Lazarus, 1961. It was decided that the accident's injuries go beyond physical damage. The worker's job required them to move between a heating room and a cooling facility, which is where this injury occurred. During an unfortunate incident, a motorcyclist collided with a tree at a fast speed and lost his life. The employer cannot evade his liability solely based on the fact that incident was caused by reckless and irresponsible driving. The driver may have been driving at an excessively high speed, but it cannot be claimed that the collision with the tree was intentional. It was determined that an accident refers to an unforeseen event that occurs without any deliberate intention, even if there is negligence on the part of employee who experiences it. Therefore, once it has been established that the accident occurred during work, the issue of negligence, regardless of its magnitude, becomes pertinent, as held in the case of Padam Devi versus Raghunath, 1950. Now, let us discuss expansion of an employer's premises. Typically, a man's work starts when he arrives at his workplace and ends when he leaves. The time spent commuting to and from work is typically not considered part of the work day and is therefore not considered to be within the scope of employment. Officially, Transportation to and from work is not considered part of the job. However, it is possible for the time and location of an employee's work to be reasonably extended. An employee can still be considered to be in the course of their employment even if they have not yet arrived at or have already left their employer's premises. It has been repeatedly acknowledged that the scope of an employee's employment is in no way limited to the actual site where they work. An employee's usage of locations that are either part of their employer's property or that they have a right to use on their way to or from work is a necessary component of their job. He is considered to be engaged in his master's affairs while he is utilizing that surplus. The case in question is Northumbrian Shipping Company Limited versus McCollar 1932. The crucial inquiry is to what extent an employer bears liability for any injuries sustained as a consequence of an incident that transpires beyond the confines of the customary work environment. The matter was deliberated upon by the House of Lords in the St. Helens Colliery Company Limited versus Houlston 1924. A worker at the colliery was injured during a journey on a specialized collier train. The colony firm had reached an agreement with the railway company to furnish its employees who would commute between the company and their place of residence with exceptional train service. Due to the fact that the employee was not obligated or constrained to travel by the special train and could have utilized alternative modes of transportation, the court determined that the injury did not occur in the course of employment. Had he been contractually bound to travel by that train, it would have been in the regular course of his employment. Additionally, it was stated that if the working environment is such that no alternative mode of transportation exists besides the one provided by the employer, it is possible to infer that the service contract includes an implicit provision mandating the use of said transportation. In Varadarajulu versus Mayasa Boyan 1954, the employer was a contractor responsible for constructing a road and the deceased individual was a laborer working under the contractor. The employee had an injury due to the overturning of the contractor's truck, which the contractor's driver was driving. The incident occurred while the truck was transporting the employees to the designated location. The court ruled that as the employer had given this mode of transportation as the sole viable option for the employees, they were responsible for the incident. In Weaver versus Tredegar Iron Ore Company 1940, it was determined that the accident occurred during employment. This was because the truck offered by the employer was a reasonable mean of transportation and no other convenient options for travelling to and from work site were available at that workplace, which was located in a hilly area. The appellant, who was a miner employed by the respondents, worked a division of the railroad that did not include a main stop. However, an agreement between the railway and the company allowed only the company's employees to board the train when changing shifts at the colliery. After leaving the colliery, the appellant proceeded to station intending to board the train to his home. However, due to the large number of employees on the platform, he was accidentally pushed into the tracks and subsequently injured by an oncoming train. As a result, he filed a compensation claim. It was held that the appellant was using the platform the respondent had arranged to be provided for their employees coming to and leaving the colliery. In Ranjana versus Union of India 1995, a security assistant in the Special Protection Group SPG was injured in an automobile accident while travelling from the staff quarters to the South Block for duty in the official SPG vehicle. The assistant suffered permanent partial disability and claimed ex gratia payment, but the Central Administrative Tribunal dismissed the claim. The injury was found to have been triggered by the accident, and the Supreme Court decided that the accident had occurred within the parameters of the notional extension of the official premises of the security assistant's actual VIP security duties. The court further mentioned that the judiciary must adopt a more compassionate attitude and build a flexible and pragmatic strategy to achieve its objective rather than maintaining a strict position. In TCS Corporation Limited versus S. Pumalai 1995, an employee was killed in a public area while on his way to work. The court determined that this was directly related to his job and occurred during his employment. As a result, the deceased employee's wife was entitled to compensation. In the case of Saurashtra Salt Manufacturing Company versus Valuraja 1958, it was observed that it is well established that if a worker is in public place or on a public road or on public transportation, he is there as any other member of the public and not in the course of his employment, unless the nature of his employment requires him to be there. An employee is not engaged in performing his duties when he departs from his residence and commences his commute to the workplace. If an employee enters a location or area that falls within the concept of notional extension, beyond which employer is not liable to provide compensation for any catastrophe that occurs to him, he is undoubtedly acting in the course of his employment. In PC Abdullah Kutti versus C. Janki 1953, it was held that contributory negligence cannot be used as an excuse to reduce the award. An accident occurred while the worker was on the job at a sawmill. The employer treated the worker's finger wounds and put him back to work. Nevertheless, the worker later contracted tetanus from his treatment, and the employer was negligent in his handling of the situation. The court ruled that the widow's compensation cannot be dismissed due to her own fault. Now, we will discuss additional risk theory or the doctrine of added peril. Students, the theory of added peril only applies when the employee is not actually carrying out his duties when an accident occurs. This means that employer cannot be held liable if an employee is engaging in the work that is not typically required under their contract or office employment, but poses an additional risk. Furthermore, the employer is exempt from the payment of compensation. If the injury, excluding death or permanent total disability, is caused by an accident because the employee was drunk or under the influence of drugs when the accident happened, the employee deliberately disregarded a safety rule that was meant to protect them, or employee deliberately removed or ignored a safety device. This doctrine is at odds with the concept of notional extension. The theory of increased risk benefits employers, while the notional extension principle benefits employees. An employee cannot hold his master liable for any harm from doing something out of the ordinary that is a part of his master's job description, even if the extra risk is inherent in the duty itself. If an injured worker had taken on a greater danger than what his employer had imposed on him, he would not be eligible for compensation under the theory of enhanced peril. The worker will not be entitled to benefits or compensation if their injury was not caused by an accident that happened on the job. Discussing the case of R.V. Mundara and Company versus M. Banwari 1970, it was held that for an employer to deny a compensation claim, they must prove more than just the employee disregarded safety protocols. However, disobedience must be intentional and there must be clear instructions. Employers have the burden of proof when it comes to intentional disobedience on the part of employees. They can argue that employees' forgetfulness or impulses are more likely to be blamed than any deliberate disobedience. However, the defense of willful disobedience cannot be used in the cases where an employee dies due to an accident that occurred while they were on the job. In such cases, employers cannot rely on rules and regulations that were put to place to ensure workers' safety. While employed by the respondent company, Ramarao was involved in the 1993 lawsuit of Ramarao Shinde versus Indian Yarn Manufacturing Company. The factual metrics of this case mentioned that the machine was to be operated from the side as directed, but the appellant tried to do it from the southern side, where the gear is located, and he hurt himself. It has come to light that the appellant disregarded management's order and removed the safety guard, despite the fact that the guard was attached to the machine with a bolt. Before starting the machine, it was also noted on the bulletin board. If they were not, the worker was required to fix them before beginning work. Despite the facts stated above, it was determined that the worker was not wrong for failing to ensure that the safety guards were installed correctly. No amount of carelessness on the part of an employee can result in their dismissal from work, the court ruled. No carelessness on the job can be considered an act of willful disobedience to a clearly stated instruction to determine the nature of an incident as an accident. It should be documented from the perspective of the affected employee if it comes as a complete surprise and was not intentional. It could have been an accident. Although he was not very careful, the worker did his job and got 2 of his fingers crushed. Therefore, his claim was held to be sustainable. Now, coming to the conclusion, the goal of providing compensation rather than granting payments to workers or their families in the case of work-related injuries should be to reimburse the workers for their actual financial losses. Employees are safeguarded from some hazards of accidents by compensation, which serves as an insurance policy. The following requirements must be met before an employer can be held liable for paying compensation. The harm must have been directly caused by anything that happened while the employee was on his job. The burden of proof is with the claimant to demonstrate that the work-related strain caused the injury or an accelerating of it. The employee's presence or active labor while getting injured is not required, nor is it required while they are working or immediately after they have stopped working. If the presented information demonstrate a higher likelihood which convinces a rational individual that the work played a role in causing personal injury, it would serve as adequate grounds for the employee to prevail in their claim. The distance between the accident location and the workplace is relevant in such situations. In summary, the law regarding the extension of an employee's premises can be summarized through the undermentioned points. Firstly, the employer must have an explicit or implied obligation to provide transportation to and from the workplace. And secondly, the employee must have a reciprocal obligation to use that transportation. Additionally, the transport facility must not just be in the form of a concession or a privilege which the employees are free to avail of, or a third point where the means of transport given by the employer is not only the most convenient means, but also the only means to reach the place of work. There is an implicit requirement for the employer to provide transportation and a corresponding requirement for the employee to use it. If a mishap takes place on the road, the employer would only be held responsible if the employee's job required them to be there. With this, we come to an end of today's lecture. Thank you so much for patiently listening. Have a good day.